Hello, this is Kent Holland, and we will be presenting the ConstructionRisk.com report, May 2013 issue. There are 3 articles in this particular issue, and I will go through them and I'll put up on slides during the presentation the actual case names and some of the key quotes that I'm using so that you don't have to try to take notes and write all this down. The first case is titled Subcontractor Owed the Prime No Indemnity Obligation, and the additional insured status did not avail the prime contractor of anything. In this case, although a subcontractor damaged a sewer pipeline during the course of construction, it owed no indemnity obligation or duty to the prime contractor for the expenses that the prime incurred in repairing the pipe. Now, the key reason that was given by the court for this decision was that a jury had found that the sub was not negligent, and the Minnesota anti-indemnity statute prohibits indemnity except to the extent that damages are caused by the indemnitor's negligence. Now, the prime also sought to be insured as an additional insured pursuant to an additional insured endorsement on the subcontractor's commercial general liability policy. But the sub's insurance carrier was determined to owe no duty to the prime to provide coverage for the damages as an additional insured. And this was because the additional insured endorsement provided coverage only to the extent of vicarious liability of the prime contractor for the sub's fault. Having determined that the sub was not at fault, the court found that there was no liability resulting to the prime contractor that could be subject to the additional insured coverage. And this was because the court was explaining that the additional insured coverage in this case was not intended to cover the prime for the prime's own liability or damages aside from what it would be vicariously liable for as a result of its responsibility for a subcontractor. This case is titled Engineering and Construction Innovations, Inc. versus Bullduk, and it's 825 Northwest 2nd, 695. It's a Minnesota 2013 decision. The indemnity clause in the contract stated that the sub would defend and indemnify the prime against claims and damages, quote, caused or alleged to have been caused by any act or omission of the sub, close quote. Now, the sub's general liability insurance policy from Travelers was endorsed to make the prime an additional insured, quote, if and only to the extent that the injury or damage is caused by acts or omissions of you or your subcontractor in the performance of your work to which the written contract requiring insurance applies. The person or organization does not qualify as an additional insured with respect to the independent acts or omissions of such person or organization, period, close quote. Now, let's look at the actual indemnity clause, and I'm going to just, I'm not going to read through this, but I am going to put it on a slide here for you to take a look at, and if you want you can just pause the video so you can read this entire clause. Let's also look at the Minnesota anti-indemnity statute, and that statute is short enough. I'll just go ahead and read the relevant portion. It says that an indemnification agreement contained in or executed in connection with a building and construction contract is unenforceable except to the extent that 1. The underlying injury or damage is attributable to the negligent or otherwise wrongful act or omission, including breach of specific contractual duty of the promisor or the promisor's independent contractors, agents, employees, or delegates, close quote. Now, the prime's argument was the following. It argued that even if the sub was not negligent, the indemnity clause was not limited to negligent acts, errors, and omissions, but was broad enough to encompass all acts of the sub. it argued that in hitting the pipeline during its sheeting operation, because what the sub was doing was putting sheets to create a cofferdam over a pipeline that was being installed. And the sub somehow hit the pipeline with those sheets. And the prime is saying, well, the pipeline wouldn't have been damaged but for the fact that the sub hit the pipe with the sheets. Now, what had happened, however, was this went to a jury trial on the merits, and the jury found that the sub was not negligent. The jury didn't explain who was responsible, but it concluded that the sub was not negligent. And one of the aspects of the contract was that the sub was required to install the sheets in the place pointed out or specified in the contract. So it didn't have any discretion how it installed or where it installed the sheets, and the sub must have argued that it followed the specs, and that to the extent that damage occurred, it was really the fault of the prime contractor or someone else who wrote the specs and not the subcontractor. The prime also argued that, okay, even if it wasn't negligent, the sub failed to pay for the repairs, and that was a breach of his agreement to bear complete responsibility for its work. So the prime tried to shoehorn in indemnity by saying, well, this is a breach of contract action. Now, the court's reasoning on the indemnity was the following. The jury's finding of no negligence constituted a finding that the sub was not in breach of its contract. So the way the court saw it was that the negligence and breach of contract for performance of the work claims were both arising out of the same duty, and therefore the jury's determination on the negligence issue allowed the district trial court to properly determine that there was no evidence to find the subcontractor to be in breach of its performance of the work obligation. So in other words, no negligence, therefore no breach of contract. The court saw them as one and the same. They're so tangled together. Because the court found that the sub was, quote, not at fault for the pipeline damage, close quote, any obligation to indemnify the prime was not accompanied by a coextensive insurance agreement, and that would therefore violate the anti-indemnity statute. Now, looking at the additional insured language, I'm just going to put up on a slide here the actual language for your review. I'm not going to read it, but you can stop the slide and pause it if you want to read the clause. The court's analysis of this was that the Supreme Court found that the language that says, quote, caused by the acts or omissions of Bulldog, close quote, means that the coverage is provided to the prime as an additional insured, quote, only in instances of the prime's vicarious liability for Bulldog's negligent acts or omissions, close quote. Therefore, unless the prime had liability for property damage, it would not be entitled to coverage as an additional insured. Now, my comments on this case. The reasoning of the court here, particularly with regard to equating acts and omissions with negligence, is not necessarily followed in other jurisdictions. And the court itself acknowledged that other courts around the country have found additional insured provisions similar to the one here to be ambiguous and therefore to be interpreted against the insurance carrier, and to therefore provide coverage to the additional insured. And one lesson to be learned from this decision, I believe, is the importance of understanding how the applicable anti-indemnity statute will be interpreted and applied to the language of an indemnification clause. For example, if a subcontractor knows that the relevant courts are going to limit indemnification that has broad language such as acts and omissions, so that it applies only to negligent acts, then perhaps the indemnity, or I should say the indemnitor, such as a subcontractor, need not worry so much about the exact language of the clause. because by agreeing to what we normally might consider onerous language, saying that we're going to indemnify for all acts, errors, and omissions, the court's still going to only apply that to negligent acts, errors, and omissions. So on the one hand, though, you have to ask, do you really want to litigate through trial and an intermediate appeal and then finally a Supreme Court appeal, as was done in this case, just to find out what the clause means? And my answer would be, why not just use plain English to restrict the indemnification to damages to the extent caused by the indemnitor's negligence and avoid all the uncertainty and litigation. The next article is entitled Design Professional Owes a Duty to Third-Party Condominium Unit Purchasers. In this case, a design professional was held to owe a duty to a third-party condominium unit purchaser, and that was a duty of care in the performance of its professional services that were performed for the developer of the project, that was the client of the designer. Now, this duty was found despite language in the design professional contract stating that there would be no duty to any third parties and no third-party beneficiaries. The court relied on the common law as well as a California Civil Code section 1368 for the proposition that if a design professional performs its services negligently, it will be liable for the damages to the ultimate purchasers of residential property. This is the case of Beacon Residential Community Association versus Skidmore, Owings, Merrill. In reaching its decision, the court acknowledged that the, quote, rule of liability may negatively impact the cost of housing, close quote. It also acknowledged that, quote, liability concerns may also limit the willingness of design professionals to undertake large residential construction projects at all, close quote. You know, my comment on that is that it's good to see the court's candid observation about the negative impact on housing and the willingness of design professionals to undertake residential construction projects in California. Particularly with regard to condo projects, it may seem like it's almost inevitable that there are going to be claims by the condo association and unit purchasers, and that this would make these projects too risky for designers and their insurance carriers. You know, I sometimes compare it to insuring a burning building. How do you price professional services when you know there are going to be claims on the project that you design? How do you price a professional liability insurance policy on that kind of project when you know there are going to be claims? So the answer might be either charge a whole lot more for your professional services and a whole lot more for the policy, or just don't do the service at all. If you are a large firm, maybe let a smaller firm that doesn't have as much at stake financially or with insurance go ahead and do that. Risk Management 101, you know, admonishes us to be wise in our selection of clients and projects and to then appropriately allocate and reduce the risk. But good luck with that when choosing to design condominium projects in California. In this particular project, Skidmore Owings and HKS Architects provided architectural engineering services as well as construction admin and construction management for the Beacon residential condos. And the homeowners association that manages the project sued them and others for alleged construction defects. The theory of the association's complaint was that the design professionals had a duty of care to the association and future residents when designing the project, and that their professional negligence caused the project to violate residential construction standards that were established in the state Senate Bill number 800. One of the key defects alleged was solar heat gain, whereby the plaintiffs said that the condo units were rendered uninhabitable, unhealthy, and unsafe during certain periods due to excessively high temperatures. And the plaintiffs further argued that the solar heat gain resulted from the designer's approval of substitutions of less expensive and ultimately non-functional windows. Now, the decision doesn't go on to describe or explain what that substitution was all about, but just as a risk management aside, this is a great concern to design professionals. You have designed something around perhaps a brand name product, or you have selected a system, only to find that the contractor comes in with an idea of value engineering of how it's going to use or equal equipment to save money. It's going to share that money with the owner, so the owner is all happy to take that equipment against your advice. The AIA B101 2007 edition addresses that somewhat by saying that if the owner does accept substitute equipment without the approval of the architect, then it relieves the architect of responsibility for that. I think that's a good clause. Certainly, to the extent that the problems here were with a substituted equipment, and then the unit owners are able to come back and suggest that the design professionals are responsible for that when the design professional did not call for that window and did not officially approve it, other than looking at the shop drawing submittal and doing that process. It seems a far stretch to say that the design professional should be liable for that. The trial court dismissed the complaint in the first instance against the designers here because it found that they owed no duty of care to the association or its members, and therefore couldn't be liable. The court found that the association had to show that the designers had, quote, control, close quote, in the construction process, and that they had assumed a role beyond that of providing design recommendations to the owner. Well, there were no such allegations in the complaint, so the court said, case dismissed. Moreover, the trial court found that, quote, even if the designer initiated the substitution changes and other elements of the design, that the association alleges to have caused these serious defects, so long as the final decision rested with the owner, there is no duty by the designers to the future condo owners, close quote. Now, the reasoning of the trial court is consistent with courts around the country, and actually it is consistent with what I believe the law should be. Is the owner is making the ultimate decision to take the substituted equipment. It wasn't the idea of the designer. The designer should have no liability for that. This was reversed on appeal, and I would say the subsequent reasoning by the appellate court is not followed in many states around the country. The court on the appellate level looked at a list of balancing factors, and I will just simply put up those factors here on a slide so you can look at those. But basically, in reversing the trial court, the Court of Appeal in California applied this series of balancing factors for rendering a determination of whether, in a specific case, the defendant will be held liable to a third person with whom it is not in privity of contract. Closing comment. This case is just one more example of how difficult the legal climate is in California for design professionals, particularly on residential projects. So when contrasted with decisions in other states, like my own states of Virginia, Maryland, Washington, D.C., we see how important a role the legislative and judicial philosophy plays in case outcome. Final decision is an article titled "Unlicensed Subcontractor Cannot Recover Against a Contractor Even if the Contractor Knew the Sub Was Unlicensed When It Executed the Contract." In this case, where a subcontractor lacked a contractor's license, the Supreme Court of Florida held that, pursuant to state statute, the contract was unenforceable by the unlicensed subcontractor. This meant that the prime could not be liable to the sub for breach of contract. Didn't have to pay anything that might have been due under the contract. The sub argued that the prime contractor was equally at fault for having entered into the contract with full knowledge that the sub was unlicensed. And so the sub argued a theory called in pari delicto, and said that this should be an affirmative defense. Now, that defense refers to the principle that a plaintiff that has participated in wrongdoing may not recover damages resulting from that wrongdoing. Now, this defense theory was rejected by the court because even if the plaintiff and the defendant were both wrong, or wrongdoers, the court stated that the defense only applies if the parties participated in the same wrongdoing and with comparably equal fault. Now here the wrongdoing of the sub was deemed paramount. In reaching that conclusion, the court cited the state statute that would impose a $5,000 penalty on somebody like a prime contractor that intentionally uses an unlicensed sub, but at the same time that law imposes a $10,000 fine on the unlicensed subcontractor and a first-degree misdemeanor for the first offense and a third-degree felony for a second offense. So the court looked at this and said clearly the law is much more draconian against the unlicensed subcontractor, showing that the sub was a greater wrongdoer. Therefore, the court refused to apply this impari delicto defense for that unlicensed sub. This case is Earth Trades Inc. versus T&G Corporation, and I'll put up a slide with the case site. That concludes this newsletter. I hope you enjoyed it. You can also, of course, read it on the website, and you can do research to find many other decisions and case notes on my website at constructionrisk.com. Hope you will join me again for a future issue of the newsletter. Thank you so much. See you again soon. Goodbye.